Thanks, Evan, for the plug. I'm Paul Farrelly, a Member of Parliament and part of the Culture, Media and Sport Select Committee. I'm a former journalist and support libel reform, but a number of nails have been hit right on the head tonight. And the path ahead is fraught with difficulty, because most MPs, funnily enough, do not like newspapers in particular. Some MPs don't like the BBC, but that's for other reasons. And the first question they will ask themselves in making things easier for the media that give them a hard time is, will this affect my ability to sue, or ordinary people's ability to sue, if we are traduced by lies and defamation? And this is where, to achieve a wide-ranging bill, and not a narrow bill that simply protects scientists with peer review and the like, the issue of the Jackson reforms really has to be carefully considered, and it's a dual-track balancing act to achieve change. And the salutary tale is what happened to Jack Straw's statutory instrument before the election. Most MPs will not be bothered about the fine detail of this. They'll do what the whips say. But the government, the coalition, Tom McNally, had better make sure his whips are on side, because what happened to Jack's instrument was that the whips, with cross-party connivance, conspired to defeat his statutory instrument in committee, and an awful lot of shenanigans to go on. It's a cautionary tale, but the issue of access has to be considered at the same time as sensible reforms to libel that get away from the chilling effect, so that we have a properly functioning investigative press, and one that hopefully is responsible as well.
Hello, I'm Sheila Layton. I work at Sense About Science. This is addressing a question that not many of the panellists brought up, which is that libel reform isn't just for the media. Millions of people nowadays are self-publishing. They're writing online about things like corruptions in corporations and local issues. And they're the victims of libel threats as well, because, as Evan brought up, when internet service providers receive a libel threat, they can be held liable for something hosted on their sites, something that they have no background knowledge about or know any of the relevant facts about. And when faced with a potentially enormous legal bill, they usually take the material down rather than defend someone who pays them £20 a year. This is like privatisation of justice. I wonder what the panel's suggestions are to solve this. There are some suggestions about, for example, the claimant will have to contact the author of the material directly rather than go through the intermediary host, or some suggestions for some sort of intermediate court order before material on the web is forced to be taken down. I wonder what the panel think.
On that last point, as I hinted, my view is that we should move to a system where, if the author doesn't take it down, in other words, the author is going to contest the case, then it should be straightforward for a serious claimant to apply for an interim court order to have it removed. But what internet service providers and the likes of Facebook and Yahoo don't want is to be judge and jury themselves, and getting a letter and being given 14 days to take it down, or they will be party to the action. And because they don't have the facility to make those judgments, and it's very unfair on a defendant who wants to stand their ground to be denied even a day in an interim court, as it were, in order to say that no, they're not going to be browbeaten by a claimant. I would like to make a point in response to what Paul Farrelly said, because Paul makes a point that I strongly agree with. And you'll be aware that in my talk I didn't talk about costs first, or indeed libel tourism, because I think that the problems of libel tourism flow from the defects in our law. So the first priority is to get the statutory change right in two ways: improving defences, but critically, as I said, to find ways of getting rid of bullying and trivial yet bullying claims from powerful claimants having early strikeout without having to feel that you're going to have to argue all the way down, even if you're confident that you'll have a good, honest comment or Reynolds-type defence, statutory or not. Once that's done, if we can get that, then I think that some of the problems of tourism go, and I think the costs fall. But I also think that it's absolutely vital, as we heard from Zoe and Razi actually, that we have to make sure, and I as a lawmaker was very keen on this, that ordinary claimants are not frozen out of the system. And as Paul indicated, MPs consider themselves, even if we wouldn't, as ordinary claimants, and they want the right to be able to take action. And what we're proposing is to make sure that legitimate claims can still be won, and that's why I'm very dubious about the 10% or 25% from the damages proposal, and I hope that the government will wait until the statute changes have been made so that we can then take a fresh look at what is then required, because if we can get the statute right, costs will fall, and therefore there doesn't have to be the drastic reduction that may make CFAs unobtainable, even in good cases.
We can beat ourselves up over this, but the media, there's been immense changes in the media, and there are attempts to tackle the obvious reforms that are needed. Charles talks about the committee that I had the pleasure to sit on as well, and that's a real change. The offer of amends was a real change. These are significant changes to make the system more workable. I've got to say, though, that I was concerned because I don't know if there was a suggestion that there should be injunctions in defamation proceedings. I think that practitioners in defamation law, that's a real non-starter. And to open up that whole area, I think would be a backward step. And where we are at the moment is you can't get an injunction, invariably you can't get an injunction in defamation cases. And I think that's rather healthy. But that illustrates the problem. If you go into reform, we're confronted by very new things, such as individuals who now have access to mass communication. Now, if you can't get to the service provider, and that individual is irresponsible, I'm being careful about my words, what can you do? How do you stop that individual from continually defaming yourself on the internet? Now, the service provider is going to be sensible because they've got something to lose. A blogger may have nothing to lose whatsoever. Is the answer to be able to go to court and get an injunction? That means opening the door to getting injunctions in defamation cases.
David Allen Green, I'm a lawyer at Preschool, and I also write for the New Statesman and Jack of Kent. Could there be such a thing as a public interest defence other than on Reynolds principles? Could there, for example, be a public interest defence which only went to the content of the words complained of when they have not been published maliciously?
But one of the problems is the amount of people that read the defamatory article. To my mind, that's never been properly addressed in the defamation bar, in defamation law. If you have a blogger and you can show in today's world that 4 people looked at his blog, you know what? The damages are going to be very quick and you ought to be able to resolve that. If you've got the Sun accusing you of being a terrorist when you're not, it's a very different proposition. And it seems to me that's an area that potentially ought to be looked at, especially today. So, sorry, when you say, I'd address that in a different way, to say, if you, as an individual blogger, for instance, are contacted quickly, you deal with it quickly, and you can show that there weren't that many hits, and you address the problem, and in that situation, it's often a misunderstanding, or you've got more information than you had at the time. That's a proper way to address it, and I would have thought it could be done very cheaply, very quickly, and with balance.
Martin Moore, Media Standards Trust. It just follows directly on from that question, really, which is, could there, for example, be exemptions for NGOs, for individual bloggers, etc.? In other words, people who are non-commercial, who are not doing it for the money, who have a relatively small number of readers. Could legally one provide more protection for those who are not doing it to sell more papers, in other words?
Adam Speaker, I'm a media law barrister. Just to pick up on Razi's point, that's already the law. The claimant has to establish that there was publication online and has to prove how many people read it. And if there was insufficient damage or insufficient publication, then it can be struck out on the grounds established by the Court of Appeal in the Dow Jones and Jamil case. So we already have a filter for...
How many?
How many?
How many would... Where's the line?
Well, with all these areas, is where do you draw the line? And if you take any issue that people have discussed tonight, whether it's public interest or whether it's the number of publications, people are going to disagree. So they'll disagree on whether the media should report that what the police are doing to investigate a criminal offence, whether they should report the name of someone who's been arrested for suspicion of murder, whether they should report his background or information about it. You will have a disagreement on that, and it's for the courts to decide where to draw the line.
John Grieger from McGrath LLP. You were talking before about libel tourism, and you'll be, of course, aware in August, I think it was, last year, that the American government, the Congress, passed the Securing the Protection of Our Enduring and Established Constitutional Heritage, the Speech Act, which effectively prevents, I think particularly it was aimed at UK defamation judgments being enforced in the States against US citizens. And I just wondered if the panel had a particular view on that, because of course that was also one of the prompters for us here to reform our libel laws, because it was certainly widely reported in the States that our libel laws were way out of touch, and I just wondered if you had a view on that.
Ronan Sylvester, Kiev Post. I'm afraid I have to disagree with Sir Charles Gray there. My paper was one of the most recent victims of libel tourism, and has hence banned all internet traffic emanating from the United Kingdom. Do the panel and does Sir Charles Gray agree with Deputy Prime Minister Nick Clegg?
We're having a bit of trouble. I'm hearing you. Maybe that microphone. You can take it nice and slowly. Yes. You yourself you say, have been a victim of.
My paper, yes.
Your paper.
Kiev Post is a Ukrainian English language newspaper who had a libel suit brought against them in the United Kingdom by a famous and well-resourced Ukrainian businessman, and has hence banned all internet traffic emanating from the United Kingdom. What else do I want to say?
Have you got a question?
I do. Does Sir Charles
yes.
Gray agree with Deputy Prime Minister Nick Clegg that rich foreigners are using their financial muscle and the UK laws to silence legitimate speech worldwide?
Well, I think Sir Charles has just answered that he thinks that Nick Clegg has been taken in by the suggestion that there's real libel tourism, which he thinks has been rather exaggerated and there's less of a problem.
But can I just ask you very quickly to say how much of your circulation is in Ukraine and how much in the UK?
Primarily Ukrainian. I mean, the newspaper goes out in Ukraine, but the website obviously is available in the United Kingdom. And
so your point is that the Ukrainian person you're talking about should have sued in Ukraine?
Exactly.
Yeah. Well, that is libel tourism. I accept that. Whether that means it's a large-scale problem, I don't know.
Nigel Smith. I'm a litigant person, as Charles knows me.
Can I ask you, do you recognise this man?
Of course I do.
Unfortunately. Does the panel realise that there's a very, very serious problem of early resolution of disputes when a litigant person has to rack up tens of thousands in costs just to find and identify the defendants in his claim? I've run up some £80,000 in costs just trying to find out the names of the people who were attacking me. And I've been handicapped and to a large extent by the judiciary as well. But if these matters cannot be resolved at an early stage, if the defendants realise they're going to have to pay a serious amount of money, if they want to apologise and resolve the matter early, or the litigant in person is going to end up with a debt he cannot pay by following through and trying to get justice through the courts. It's an impossible situation for a litigant in person trying to resolve a matter at an early resolution if he's putting himself in debt for the rest of his life.